Okay, I think we'll start. Welcome back, everybody, to the second panel of our conference today, which is looking at corruption and the rule of law. I think we had a really good opening panel this morning, which really set up a lot of the issues that we're going to talk about for the rest of the conference. But I think that what we get today, and during this discussion, I hope we're going to look at some specific cases. So we're going to look at the case of Romania, the case of Poland, and the case of Hungary on corruption and the rule of law with our amazing panelists, group of panelists that we have here. You have the bios in the booklet, so we don't need to read out their bios. But I'm very grateful that I have the opportunity to chair today's panel, which is also another challenge because it's the one right after lunch and right before the wine tasting. So we will do our best to stay on time, and but at the same time keep it very engaging and to stimulate discussion. So I will ask our speakers to keep it to 10 to 15 minutes for your opening remarks. And then we will have, I'll have maybe a question or two, and then depending on time. And then we will certainly save some time for discussion and engagement with you as the audience. So I think with that, we can go straight into our panel. And we will start with Professor Elena Simina Tănăsescu, who will look at the fight against corruption in the Romanian Constitutional Court.
Thank you. Thank you so much. Sorry. Thank you for inviting me here. I know it's a difficult task for me to keep you up, despite the postprandial torpor, as they say, but I'll do my best. The title of my presentation was actually, and it's a little bit confusing, I know, but it was on purpose. It is the fight against corruption in the Romanian Constitutional Court. It was not just a mistake. No, it was a mistake. No, okay. Actually, it is the way in which the Constitutional Court fights against the fight against corruption, to make it more clear. But it was on purpose, and I'm glad that you allowed me to to make this little precision. Nobody's perfect, and I'm nobody. I'm a lawyer. I'm a lawyer by training. I'm a lawyer by profession. I'm a judge, worse. And I'm perfect. I like it. I really like. I enjoy my job. I like what I'm doing. I like applying laws. So you will understand that it is a bit difficult for me to be slightly critical, as I will be, of a jurisdiction that I'm on the bench of which I'm sitting, actually. So please bear with me if I cannot say anything about pending cases or possibly cases that I will face. You will understand that I have a devoir de réserve. But I'm open and I'm free to speak about cases that the court has dealt with, and that's what I'm going to do. So I will just say a few little truisms, things that everybody know, and then I'll pass to the cases that I think are giving a different perspective on the fight against corruption, the way it was dealt with in Romania. Now, most of the people here in this room know that the prosecutor in charge with the fight against corruption from Romania went now to the EU and is now the lady fighting against corruption at the level of the EU. And that has been a success story. I'm here not to tell you that success story, but I'm here to present, in fact, the other side of the story. Not really the dark side of the moon, but what has been done or how this entire fight against corruption actually was undermined from inside by the other institutions in the Romanian state. Now, among the few truisms that I have to say, there are things such as, you know, that there is a tension between democracy and rule of law. Obviously, democracy means rule by the people, and state of law means framing and limiting that power of the people. So obviously, there is something difficult there. We tend to take these terms for synonyms, but they are not. Among the other truisms that I have to say is that the power of the people, which is limited by legal rules, hence my role, well, that kind of power is given to the people and to their representatives in order to protect public interest and not their private own interest. That's obvious. And of course, that good governance and state governed by the rule of law does not go hand in hand with corruption. And here I have to make a little pause. What is corruption? Well, corruption doesn't have a definition. It doesn't have a legal definition. It doesn't even have a general, broad or universally accepted definition. Corruption may be dealt with from a legal perspective, meaning a civil servant is simply not doing or is not performing his or her task, or is doing something else then in order to pursue a personal interest. Corruption may be dealt with in terms of, there's a definition, market-oriented, market-centered, whereby the market is distorted as to provide the specific interest. There is another definition which deals with public interest, whereby you misuse the public interest as to provide to cater for your own personal interests instead of looking at the general one. So, okay, corruption doesn't have a definition. However, as of lately, and let me do another little between brackets, what we think that that is corruption, it may be perceived as such in one society at some specific point in time, and it may be totally different in other societies or in other times. Huntington even said that from the perspective of economic growth, and I'm quoting here, corruption is a positive sign that a society is on the path of modernization. Because he said, quoting again from the Political Order in Changing Societies, that in terms of economic growth, the only thing worse than a society which is a rigid, concentrated, dishonest bureaucracy is one with a rigid, over-centralized and honest bureaucracy. So for him, corruption may even be a lubricant easing the path to modernization. See, corruption is really a multifaceted word, concept, and reality. So I think also that for the average person, when we talk about corruption, the average citizen would look at corruption as to a moral, I would say, attitude. People don't care that much of what's going on in the high spheres of a legal realm. What they want to see that the general interest is well taken care of, and that the public officers are doing what they have to do in order to pursue that general interest, and not to enrich or take advantages from the positions that they're temporarily fulfilling. So the phenomenon of corruption can be dealt with from very, very many perspectives. Nevertheless, nowadays, the perspective that is mostly in use, it is a legal one. It is a definition that has been given back in the 60s, actually, by Joseph Nye, who, in one of the books, Corruption and Political Development, he said that corruption is a behavior which deviates from the formal duties of a public role in order to acquire wealth or status or other advantages. You may notice that this has to do with law, in fact, because it refers to a behavior that deviates from the duties of a public servant. So a public servant is supposed to he or she has some attributions, and if he or she doesn't do it, or performs them badly, or puts conditions in order to perform his or her duties, then we have corruption. So this is a definition, this is a legal definition, hence my role. But this is a very narrow definition, because it takes as a referential the violation of existing legal rules. What about another phenomenon which has also been looked at in the legal scholarship? What about what it has been called legal corruption? It asked, what about a phenomenon where the very legal rules are adopted through a corrupted process or with corruption in mind? They are adopted as to allow corruption. And this is the framework, this is the paradigm in which I'm making my entire presentation today. Because what we have seen in Romania, it was on one hand a beautifully successful and marvelous fight against corruption, because number of corrupted persons were caught. They were shown on TV. It was population was quite happy about it. Not only the population was happy about it. many things were considered to be advancing. Actually, they were considered to be in progress. So Romania was somehow a case to show. Actually, the Romanian DNA is the acronym, Department of National Directorate for the Fight Against Corruption. It was heavily promoted all over the world, and it has been taken as a role model for Serbia, for Bulgaria, for Moldova. So one may say it actually proliferated. But on the other side of the coin, if you flip it a little bit, you will see that actually there was also an ongoing legal corruption in this last meaning, whereby, interestingly enough, not parliament, not the executive, not the legislative or the executive, but the Constitutional Court was actually not fully undoing, but touching upon the legal framework dealing with the fight against corruption as to actually limit the fight against corruption. I'm not here to promote a heavily repressive public policy with regard to corruption. I'm fully aware that when dealing with the phenomenon of corruption, one has to take into account both the preventive and the repressive arm. And the Romanian legislation displays a large amount of instruments dealing with corruption on the preventive side. We have declarations of interest, declarations of wealth, there are many instruments. However, we were talking in the previous panel about populism. Well, that is such a thing as the criminal populism. I mean, yes, people are much more satisfied when they see that the bad guys are punished, and the repressive arm of corruption was more interesting, and it was more. It took the public image. It has stolen the first place in the public imaginary as well. But I also, so I'm not promoting excessively repression, but I also believe that when we deal with such a phenomenon as corruption, which is not, again, a very clear concept, we have seen that it may be dealt with in different manners, I think that we have to balance very carefully the preventive and the repressive one, and that the principle of proportionality has to be respected fully in terms of the behavior, the attitude that may be labeled as corruption, and the sanctions which are attached to it. Because simply insisting on repression, on punishment, does not necessarily produce the willingness to change social behavior, which may be generated by education, by culture, and sometimes simply by the need to survive. So one has to take into account a large range of elements when designing a policy. Nevertheless, what did the Constitutional Court, and here I will go very quickly in the case now. Well, these preventive and repressive arms of the attitude towards corruption, they have to be dealt with, of course, by the representatives of the people, that is by Parliament. Now, Parliament may adopt wrong laws. If those laws are wrong, they go to the Constitutional Court. And the Constitutional Court has as a task to protect fundamental rights and to see that the laws are constitutional. Under the disguise of protecting fundamental rights, the Romanian Constitutional Court has actually taken on itself to dismantle the fight against corruption. How? On the preventive arm, the National Agency of Integrity, that is an agency that is actually overlooking over the declarations of wealth and of interests. Already in 2010, the court said that this agency cannot perform jurisdictional activities. I told you I'm the bad guy, I told you I'm pervert, and I'm a lawyer. What does it mean, jurisdictional? Well, you have to bear a little bit with me. Basically, the Constitutional Court said that that agency cannot simply say that people have accumulated too much wealth compared to their revenues. It is not within its realm. This has to be a decision taken by a judge and not by an agency. Well, it sounds a bit odd to those of you who know that an agency, the word, the very term of agency, it is an executive body that actually also has jurisdictional attributions. Well, our Constitutional Court said it may be so for any other agencies, but not for this specific one. This one, it has to be it has to do its work under the control of the judge, of a judge generally. It went on saying confiscation of wealth, which was proven to go beyond the revenues of the person. Well, this also has to be done only by a judge and not by this agency. So not only they cannot just observe, but they cannot confiscate. On the repressive arm of corruption, the Constitutional Court said in 2016, I have the details if you want, I have even brought them on paper with me. If you want, I can quote from the decisions. It's really interesting. The Constitutional Court said the legal definition of corruption, it's too broad. You know, Joseph Nye said that corruption means a behavior which deviates from the formal duties of a public servant. What are the formal duties of a public servant? Well, they may be written in any type of legislation. They may be in a law, they may be in a regulation, they may be in the customs, in the way in which people are doing things, in the good practices. You know? Well, our Constitutional Court said, sorry, if we talk about criminal repression of corruption, everybody knows that in criminal law we have the principle of legality. Therefore, corruption is only if a civil servant does not perform the duties that he or she was prescribed by the law, and not by any other type of legal instrument. So if civil servants were wrongly doing according to the duties which were prescribed on them by the government or by local authorities or by the internal regulations of their offices, they were no longer considered corrupt. It was no longer a deed of corruption. You can imagine that many have actually escaped with that. Corruption was also declared by the Romanian Constitutional Court not to no longer be a threat to national security. In a country where actually corruption was so high and so widely spread that it actually had an impact on the national gross product, where one was considering of its impact on the national budget, I'm not discussing here on the opportunity of the decision to include corruption as an internal part of the national security, but it could have been imagined as such. It could also not have been imagined as such, but this type of decision belongs with the representatives of the people and not with an technocratic authority appointed by those representatives to a great extent. Nevertheless, the court took it upon itself and said, no, corruption is not a concept to be included in national security. Moreover, the Constitutional Court ruled upon one tiny little detail of procedure, and I warned you several times, I'm a lawyer. You'll have to really go with me here. When prosecutors start a case on corruption, they start the investigations, and generally they start them in rem, meaning in general. You don't know who did it. You just notice that there is a discrepancy somewhere. And you just do your investigation, and at some point in time, you're running out of proofs, or you no longer have clues, you just have to stop a little bit, and then you do other cases, and then you come back. But there is a limitation period. You cannot just indiscriminately or without any, just infinitely prosecute somebody. There has to be a limit in time. And there is a limit in time. But that limitation can be interrupted if certain procedural acts are performed. Now, those procedural acts, because it's an ongoing investigation, they don't necessarily have to be public. In fact, they are not public. They are not meant to be brought to public knowledge. But there are some that may or even have to be communicated to the respective party, to the ones that you're suspecting that they might be involved. But there are some that cannot be communicated, not even to the suspected people. The Constitutional Court just declared every such procedural act has to be communicated to the person. Well, of course, when you let know somebody that actually he or she is under investigation, he or she will simply leave the country, as it just happens. The Romanians among you here know of some famous cases where people got the information officially because prosecutors were obliged to, and they just left the country. Finally, In dealing with the institutional side of the fight against corruption, the Constitutional Court took relatively recently another decision saying that there is this general body of prosecutors and the specialized section which deals with the fight against corruption. Well, the Constitutional Court simply said for the prosecutors to be selected in this special section, they need to have a certain length of service within the prosecutorial services. Initially, it was 3 years. Then it was increased by the legislator to 5 years. Then it was again increased by the legislator to 8 years. And then the Constitutional Court said, well, that's not fair. Prosecutors who can who can be promoted to the highest prosecutorial office in the country, next to the Supreme Court of the land, they need to have a length of service of 12 years. Why should the prosecutors which are going to this DNA only be requested to have 8 years? Why shouldn't we, Constitutional Court, impose them also the 12 years? This may seem benign, but in fact, it simply depopulated the special prosecutor of those who are undertaking the inquiries. So, in step by step, without being noticed, very discreetly, I have counted at least 30 decisions that were adopted by the Constitutional Court of Romania since 2010 until this very summer. In 30 decisions, the Constitutional Court of Romania has managed to actually keep on fighting its own fight against the fight against corruption. I have recently this summer received a very nice meme on WhatsApp, which went on like this. In Romania, the fight against corruption is like sport fishing. They catch them, they show them to the public, they take photos of them, and then they release them. That's my conclusion. Thank you very much.
Thank you very much for that very interesting insight into the Supreme Court, I'm sorry, the Constitutional Court here in Romania, and I'm sure we'll get into some details during the discussion. I hope so, because I have already some questions. So now let's move to, so I guess we will move northwards towards Hungary, and I will hand the microphone and my chair over to Andrzej Sadecki, who is with the Center for Eastern Studies in Warsaw.
I can find it.
Okay.
It's on the desktop. Okay, thanks. Next. Okay, thank you, Adam. First of all, I would like to thank the organizers for inviting me here to this wonderful event in Turda. My presentation, as already announced, will be dealing with Hungary mostly, and about the rule of law and corruption, but from one very specific point of view, namely the role of external actors. We actually discussed it a little bit earlier on. There were some reflections about the external threats to democracy and rule of law. There were discussions about democratic regression or backsliding. So I hope this presentation will further invigorate this debate. So just a very brief introduction. I want to focus on some case studies, but just to briefly lay the ground. So, as you probably all know, well, the case of Hungary in the past 12 years of the rule of Viktor Orban and the Fidesz party was quite well sort of debated in Europe and raised a number of controversies. Here, I would like to focus only on the aspect how on this one particular aspect in which in the past decade we experienced the weakening of checks and balances and judicial independence with the centralization of corruption, control of procurements, etc. It's obviously corruption existed before on a rather large scale. The specificity of this period since 2010 is that it became a sort of systemic corruption in which the party itself is involved and plays a sort of definite role. There are several explanatory frameworks and concepts how to explain this process. One of them I found useful is the party-state capture, which distinguishes between party-state capture and the sort of corporate state capture. So in most of the countries in Central and Eastern Europe, we are dealing with a corporate state capture in a way that we have, I mean, that's what we ordinarily call corruption, a company sort of trying to influence the legislation or regulations and in this way corrupting a given official. So we have many examples of that in Romania, in the Czech Republic, Slovakia, and other countries. Hungary is a little bit of a different case when we can talk about the party-state capture, when corruption is actually sort of channeled or organized by the ruling party itself. So there is this another quite popular concept of post-communist mafia state. There was this book that became quite an important point of reference. Obviously, this analogy is not perhaps fully precise, because obviously the state does not use entirely mafia measures. It does not use violence primarily. The author talks about this sort of bloodless bureaucratic coercion, but in a way, the way how the state is organized, or how the party is organized, reminds the criminal sort of organization. So now I would like to focus on two cases about the role of the authoritarian regional powers in corruption and rule of law in Hungary. Very briefly, it started with a sort of political idea of opening to the East policy. So this kind of direction in foreign policy, which sort of advocated creating deeper relations with these countries. Originally it started as a sort of realizations that the West is in crisis. It was right in the aftermath of the big international financial crisis. So there is this need to find alternatives in these kind of either emerging powers as China or those that can offer some leeway in particular sectors such as Russia, and then it slowly developed into a very sort of wide economic and political cooperation. So just briefly to give you a sense, this is where Hungary stands in the Corruption Perception Index. And on the right-hand side, you see the change, how dramatically it followed in the ranking. Obviously, the Corruption Perception Index is only indicative partly. I mean, it shows how the corruption is perceived by the people, and obviously it favors a little bit Western countries in a way that it does not, for instance, include the corruption, the sort of export of corruption. What I mean by that, like you have companies, let's say from Finland, which is very high up in the ranking, that conducts corruption activities abroad, so it's not reflected here, but in the country where the corruption occurs. But anyway, I think it is indicative when where Hungary stands here, a little bit below other countries of the region, such as Poland, Czech Republic, Slovakia, or Romania. So moving to the first of the cases I wanted to explore is obviously the case of Russia, that is currently also very much discussed. This cooperation, strikingly maybe, started to kind of accelerate in times when Orban took power, who was previously a rather anti-Russian politician, but then he underwent this sort of significant transition, and slowly, step by step, Hungary became engaged in a number of in a number of joint projects with Russia regarding energy, regarding railway cooperation, vaccines, and others. One case I want to focus on a little bit is the expansion of the nuclear power plant, as this is the largest infrastructural project that is executed in Hungary since 1989. So huge money involved, big political stake too, and this was definitely a sort of milestone in the Russia-Hungary cooperation. With all of a sudden, in 2014, it was announced that Russia will be given the project with no tender, with documents classified for many years, with a little bit kind of dubious financial model. And you can maybe recall that it was agreed just before the annexation of Crimea. So in a sort of Russia probably rushed to have this agreement as soon as possible. And this agreement, as I said, is a very kind of intransparent. We also had a discussion about the role of transparency for democracy. So here we have a case of an extremely intransparent project with a financial model based on a large loan from a state bank in Russia, covering 80% of the investment. So here there is a significant sort of political stake, and it's not only regarding foreign policy but domestic politics, as this became a sort of one of the major sources for the local oligarchs linked to the ruling party to get the public money to construct certain parts of the power plant. Even the cases of the party-linked oligarchs taking over foreign companies in order to realize some of the works. And here you have also an interesting involvement of the Western actors in facilitating the deal. So it's not only a Russia-Hungary story. So you have a sort of unclear role of a certain German lobbyist that first facilitated the deal between Hungary and Russia, and then facilitated this sort of agreement and the green light that was given by the European Commission to the project. So the second case I wanted to show is quite similar, because these connections are basically based on these large infrastructural intransparent project. So here, in a similar way as with Russia, Hungarian government started to develop these large infrastructural project, among others. Of course, there is cooperation also in telecommunication. Hungary is the only one country that now developed its network in cooperation with the Chinese companies in the EU. But I would like to focus on one particular case, namely the Belgrade-Budapest railway, which is similarly, again, big project, a lot of concrete, a lot of construction works that was given to the Chinese companies without the tender, with a huge interstate loan again, and with lack of transparency, with no tender, documents classified for 10 years, etc. So here it was even calculated already by some Hungarian experts how much of the value of the project will go to the oligarchs linked to the Fidesz party, and it's around 40%. So we have this sort of scheme of these large infrastructural projects, which are intransparent, which are mostly have classified sort of data, and it directly benefits the sort of business circle around the party, which are in turn supplying, buying out the media that are becoming supportive of the ruling party. All these projects have actually very large delays, so it raises the question to what extent they are all about, kind of siphoning out the funds and not only leading to some concrete effect. They are giving access to strategic sectors for these two external actors in energy, in telecoms and others, and they have seemingly no political strings attached, at least for the ruling party. So in the logic of the Fidesz party, it gives sort of Russia and China are not the actors, contrary to the West, that are intervening in the domestic affairs in Hungary. Of course, giving access to these strategic sectors gives China and Russia quite a big impact on Hungarian politics, but from the individual point of view of the ruling party, it's sort of win-win situation. And finally, the consequences for the foreign policy of these projects and this cooperation is that Hungary in return is ready to give political concessions to the authoritarian countries, so in this way weakening the Western unity, if it exists. It partly exists vis-a-vis Russia and China. So we saw it recently with the EU discussions on the sanctions on Russia. Hungary was kind of trying to water it down, etc. And there are many other examples of that. So in this sense, we can also talk about this sort of political corruption. So I will stop here and looking forward for the discussion afterwards. Thanks.
Thank you very much for the very interesting case. I think we will have also some questions for further details and looking at, true corruption in Hungary and how it is visible and we can see it. Plus the fact that there's a lot of these external forces involved, I think is very important, and we keep that in mind as well. So now I will hand the floor over to Professor Pavel Leidler, who is the Dean of the Faculty of International and Political Studies at the Jagiellon University. So please. Okay.
Good afternoon. First of all, I'm really very grateful and honored to be able not only to speak in this distinguished panel and very interesting and I think challenging topic. We'll have a fruitful discussion, I'm sure. But I'm also very grateful that our Polish delegation, representatives of the Jagiellonian University and the center represented by Andrzej, were able to come here. Thank you for your hospitality. Thank you to the Ratio Forum, thank you to LSE Ideas, and I'm very glad that it's not just a coincidental meeting. We are part of the family, if I can say. We are institutionalized. I will talk about some institutional flaws in Poland, but I think this is not a flaw. This is the future of a great collaboration. I'm looking forward, and please feel invited also to Krakow, to Poland, to continue many of our discussions. Thank you. Well, I need to tell you, it's not a secret. I'm mainly a scholar focusing on the United States. So American studies is the area. I'm also a lawyer, however, not practicing lawyer. So it always depends who asks me. Sometimes I'm proud I'm saying I'm a lawyer, but when I meet real lawyers, I'm saying I'm a political scientist and a little bit of lawyer. It is also challenging. I mean, on one hand, I think it's good to be a constitutional scholar, to have these, two legs in two realities. But on the other hand, of course, it's important to look into a certain topic, not only from interdisciplinary perspective, but from also perspective of a concrete scientific reference. And I will try to be a little bit of a lawyer and more of a political scientist, if possible, with regard to the topic that I would like to share with you. And one explanation why, of course, I'm referring to Poland, as I come from this country, and I'm also not only as a scholar, but also as a citizen interested in what's happening in the country. And many of the reforms that had been imposed in recent years do have an impact on the society, on the image of Poland abroad, but also on our research. I'm talking about various political scientists who even comparatively are trying to look into various changes in democracies. And what I would like to refer to today is a topic exactly focusing on a concrete period of time, concrete governance, a concrete institution. But I think it is somehow a repetitive pattern, not only because what's happening in Poland is also reflected in many other countries. I'm meaning the polarization of the society. I also refer to the process, which I'll try to explain, which is part of the project I'm conducting with my colleagues in Krakow. It's called Constitutionalization of Politics. So a process where non-judicial actors, non-judicial subjects are more and more involved. They believe they have power, no matter if they're representatives of the executive or legislative branches. They have the power to redefine the meaning of the Constitution. If they cannot do it with the use of these traditional institutions of judicial review in the US or of constitutional tribunals in Europe, they're trying to impose that via different tools, which I called constitutionalization of politics. This office, which I would like to refer to with a couple of case studies and also a little bit of theoretical background, is an office that is constructed in a way which is not similar in many European countries, but it's similar in the US, which makes it really interesting for me as an American studies scholar, because I conducted my PhD writing about the Office of US Attorney General, trying to prove, well, a poll did not change the system in the US, it's obvious, but trying to prove that there is a conflict. I called it conflict of powers, of conflict of competences, of someone who is at the same time a minister of justice. Of course, in the US, you don't have ministers, but it's a secretary of the Department of Justice, politically appointed, and at the same time, the attorney general, called the chief law officer of the nation, the most independent, where the law is the main loyalty, not politics. The problem is that the attorney general can be appointed and removed, of course, with advice and consent of Senate appointed, but removed at any time by the president. So it's a political post. And we do know a lot of examples in US history when presidents forced attorney generals to find legal solutions, legal advisory, in order to legitimize, justify certain policies. It has been happening since Andrew Jackson in 1830s, but it's still happening today. And by the way, just a brief reference to Romania, I just realized reading one of the articles that the last Donald Trump's Attorney General, William Barr, who was also very controversial in many respects, visited Romania. and met with the president, met with many politicians. So there are a lot of connections, proving why it's important to talk also about the US as a consolidated democracy, having also kind of challenges and problems. As goes for the theoretical background, very briefly, you all are aware of these concepts which I'm presenting here, namely judicialization of politics and politicization of justice. Judicialization of politics is not a new concept. However, in the US, it's really it has been broadly researched, and there are a lot of proofs that the construction of the system in the US, especially the Supreme Court being also the constitutional tribunal in the United States, forces a growing impact, involvement of active judges, active justices, no matter if they're liberal or conservative, into new areas of the social reality, economic reality. Of course, this is not the topic to discuss right now, but everyone is aware of the fact of the consequences, social, legal, political, economic, and many more, of the decision of the Supreme Court in the abortion case in June this year. That's just a point to show that judicialization of politics is present, and it's a fact. It's just a matter of whether you're more conservative or less conservative, you like that or not. This is a typical approach, and I think this approach is also a repetitive pattern which will help me or help us to understand the attitude of the governing party in Poland towards Constitutional Tribunal, because there were a lot of changes in the operation, the structure and powers of Constitutional Tribunal in Poland. It has been deteriorated somehow, but the paradox is that before, the Constitutional Tribunal was the biggest enemy of the governing party. But when they made these changes, having direct impact on who is in the tribunal, and they like the way the tribunal now reads the Constitution, suddenly it's the best, the most legal institution that you can realize. The other process, of course, is politicization of justice, and I think it comes from judicialization of politics. If the judges have so much power, it's good to have impact on who the judges are. So it's important to look into the different institutions and structures and powers of the executive or legislative branches. How come they can influence the operation of the judicial branch? Of course, why we are talking about this? It's about corruption, it's about rule of law and democracy. It's obvious for us that even 200 years ago, if there were books written, they would be very thin compared to contemporary books on democracy, definitely. But if they were written, of course, elections were one reference, and the other a reference independence or sovereignty of the judicial branch as an important element of democracy. So if the judicial branch is politicized by the process of choosing proper judges who are having concrete ideology or who are thinking in a concrete way, which sometimes you can predict, it means that the process has certain flaws. And I believe in the US there are such certain flaws, but also they appear in Poland contemporarily. But I would like to introduce another concept which we are focusing in our project, which we call, maybe not perfectly, a constitutionalization of politics. So we are talking on one hand about the process of defining, redefining, trying to find different tools into having influence of what the Constitution means, what certain constitutional provisions, certain constitutional clauses mean. It's happening in many countries. It's done by the presidents in those active systems. I'm talking about the mixed form of government or presidential form of government, but it's also happening by the activities of the governments in parliamentary systems and, of course, the legislative branch. One of the consequences, of course, is the change in the attitude towards the hierarchy of sources of law, where they believe that in some circumstances, and this is Przemysław, where I will refer from time to time to your exceptionalism and exceptional presentation, but also exceptionalism as a concept, that they redefine or they label certain timing. It's not only COVID. There, national security is a kind of key issue. How you do that, and then they believe they have more power to read the Constitution in a different way, or to avoid the Constitution and trying to impose many new pieces of legislation without due reference to the hierarchy of the sources of law. But we are also talking about the legitimization, justification of certain policies. And I think a very good example, sorry to go once again to the US, but clearly constitutionalization of politics has been observed during George W. Bush's governments when he introduced terrorist surveillance program in the US, which was secret. On one hand, we can imagine it, but he imposed it using only his executive powers, which was generally against the Constitution and against Congress. And when the leaks went to the press, Bush, with the help of his Attorney General, which is important, and with the help of the Office of Legal Counsel, they found justification by a memorandum. So a memorandum written by a group of lawyers helped them to justify or expand the powers of the president. And again, it's not now time to discuss whether it was correct or not because of the time of emergency or exceptionalism in the post 9/11 reality, but the fact is that presidents believe in the US at many times that if some other tools are not working, they have the ability, because the whole executive power belongs to them. This is the theory of unitary executive. This theory doesn't exist theoretically in Poland, but I believe that also those who are in power believe that the executive, as was said during the first panel, that the executive does have today a broader powers because of the reality that they're facing. So very brief, let's leave the American perspective right now and let's look into the European perspective. Most of European countries do have that division. So you have Ministry of Justice, a political post, and you have Prosecutor General or Attorney General. And I believe, theoretically, I'll try to show it on the case studies, that this is more healthy. I'm not saying there's no corruption in that system, but I'm saying that there's more potential for political corruption in the system that exists in the US, leaving it, but also in Poland nowadays. And the Poland example is very interesting because looking from the moment of the transformation from 1989, it was unified. It was unified. So this was, the Solidarity movement decided not to make a huge reform of the system, referring even to the interwar period when Poland was last time sovereign country and free country, and that they unified. So a Prosecutor General was at the same time Minister of Justice. There were maybe not many proofs of corruption. However, there was a period between 2005 and 2007. Not coincidentally, I'm referring to it. It's a period when Law and Justice Party was governing for the first time, and Zbigniew Ziobro, a name to remember because he will be the hero of my second part of the presentation, the case studies. He is now Prosecutor General and Minister of Justice. He used to be the one at that time. And this forced the next government, the Civic Platform, more liberal government, to think about the reform. And they imposed that reform, and the parliament, with the majority of Civic Platform, decided to change the system in 2010. So they divided it, as in most of European countries. The division meant that the Prosecutor General would be appointed by the President at the request of the National Judicial Council. And of course, Minister of Justice would be appointed by the President, but at the request of the Prime Minister. So it would be political and legal, if we can simplify that. And there was only one such Prosecutor General who had a 6-year tenure. Tenure was also an important tool in diversification of the powers of different branches. And it was Andrzej Seremet who was chosen, and he held that position till 2016. But in 2015, Law and Justice and other parties, which created a coalition called Zjednoczona Prawica, United Right, they're still governing, they took over the government. First, they won the presidency with Andrzej Duda, and then they won the parliamentary election. And they already announced that one of the first things they will do, they had to wait till the end of the tenure of Seremet, they would unify again that office. And interestingly, and that's again where I'm referring to Przemysław's presentation about exceptionalism, they were using the argumentation of, quote, public safety and security. So that the reason is not because the system is better or worse, or that it's historical, traditional, no. It's a difficult moment for Poland. There are a lot of things we need to do. It's an emergency time, so we need to react. And the way to react is to impose institutional reform. That's why they use security in very broad context. It would be national security, domestic security, or generally security. So for the public purpose, for the people, they did that. Of course, Zbigniew Ziobro was at that time Minister of Justice, and he already knew that after Seremet, he would become the Prosecutor General in the unified office. It was very important for him because he was not only the face, he was not only the rhetorical voice, but he was also the main ideologue behind a huge reform of judiciary, huge reform of constitutional tribunal, and also of the prosecutors' offices in Poland. So first they decided to change the law, and then when they took the power, they decided to implement that. And I'll just very briefly refer to 4 different approaches, 4 different case studies of the consequences of that merger. But before that, let me briefly refer to what you see in a slide, so how the powers expanded since 2016, the powers of the Prosecutor General. So the Prosecutor General had even more supervisory powers over the functioning of prosecutors' offices. It meant that, on one hand, that they limited the tenures. They gave more powers to the Prosecutor General to remove, to relocate, and also to impose disciplinary measures on different prosecutors in the country, which was not so clearly reflected in the law before. Also, they resigned. Well, it was not official, but as a consequence, they resigned of these professional contests. So, like, substance was not the most crucial issue. The loyalty was more important, which we could see in the numbers. I'll share some of the numbers of what has happened since 2016 in the removals of the or demotions of the prosecutors. We are talking here about regional, district, and county prosecutors of different levels. So here I come to the main research question. Whether, I mean, what's the consequence? What's the result? What's the impact of the merger, of that concrete institutional change? Of course, analyzed through only one tenure of Zbigniew Ziobro, who still holds the post of Minister of Justice and Prosecutor General. And very briefly, because we don't have time to discuss it, if maybe during the discussion later we can refer to some more details. So, looking into the numbers, from 2016 till today, Zbigniew Ziobro replaced 11 leaders of regional prosecution offices, 45 leaders of county prosecution offices, and the vast majority, 90%, of 342 prosecutors leading district offices. About 200 prosecutors retired after the implementation of the reform as a protest against the Ziobro as the leader of the prosecutor's office in Poland. On the other hand, we could observe, we call it a fast-track promotion of other prosecutors who proved obedient or somehow connected with the governing party. So what could be observed was the systemic demotion of several prosecutors and involuntary transfers to other cities as quasi-disciplinary penalties. It became kind of an everyday obvious thing. However, the society didn't react directly to it. The society reacted to the moment when they started to look into the judiciary, into the Supreme Court, and into other institutions of the judiciary. So the second case refers to the deterioration of the role of Constitutional Tribunal. And I'm aware it was not only Zbigniew Ziobro, it was not only him as a Minister of Justice or the Prosecutor General, but that office was used in not only promoting, not only in the statements, not only in building the rhetoric, but generally into leading many of these reforms, into writing the law and then initiating it in the parliament. So Constitutional Tribunal in Poland existed, that may be surprising for those who know the communist, post-communist transformation period, since 1985. So it's like a last effort of a dying country to prove that they are trying to do something democratic in a non-democratic regime. Since 1989, it was reformed, but it was clearly, a typical European Kelsenian vision of how it should work. A central institution of independent judges who have impact on the review of the constitution in certain procedures. And just one case study to show you this very relative approach towards Constitutional Tribunal. I mean, you can love it or hate it. There's nothing in between. So in 2007, probably you had the same thing, and each of our countries had a huge problem with the lustration process, the process of vetting, reviewing the secret data of collaborators. Not every country succeeded so much as Germany did with the Stasi. We had a huge problems with this. And there was a law of lustration created by Law and Justice Government in 2005, which generally, again, not too much time to discuss it, but was to lustrate, to review almost everyone. I mean, limiting powers of many people who lived under the system, who did anything under the communist system. And it felt it's unconstitutional, but we had to wait for the decision of the Constitutional Tribunal, which happened to come in 2007. And I remember then the statements of two leaders. By the way, still the two leaders are the faces of two different wings of politics in Poland. So Jarosław Kaczyński, leader of Law and Justice Party, said, "This is the worst decision of the worst and most politicized Constitutional Tribunal ever." And Donald Tusk from the Civic Platform at the same time said, it's the most independent, most bipartisan and honest constitutional tribunal. It's great. So I can tell you, not to say whether we love Tusk or Kaczynski, if the decision of a constitutional tribunal would be opposite, you would hear the same language. Just they would say the opposite things because they believe, as politicians do, having impact on these institutions. It's a great legacy to come to have impact what the Constitution means on social and economic relations. So Kaczynski said, one time when we come to power again, after, he said, we will definitely change the law. And they changed the law with the help of the president. They didn't approve the legally chosen judges, 5 of them, and they chose their own judges by the new parliament, which caused a lot of trouble in Polish politics, because Constitutional Tribunal imposed a decision which denounced the parliamentary decision to designate these judges, and the government decided not to publish that decision, which is a formal element of becoming binding of that decision. And also the Supreme Court made a statement and a resolution against that, as they said, illegal process. And interestingly, to hear Ziobro and other members of the government said that, to quote, Supreme Court judges were a group of buddies preserving a status quo of the old regime. This is this rhetoric that they used. Yes, they wanted to take out all the communist legacy from that institution. So there was also Ziobro's individual approach. He decided to start, it did not finish, but he decided to initiate investigation against Andrzej Rzepliński, a professor who was the president of Constitutional Tribunal, because he was so much against what Ziobro and his party did. So you do have this prosecutor general's perspective here. They also, after the end of the tenure, they changed the president. Julia Przyłębska is now the president. So for Kaczynski and Ziobro, this is the best, most impartial tribunal in history of the country. And for the other part of the society, it is not Constitutional Tribunal, it is Julia Przyłębska and Kaczynski's tribunal. And of course, it's not only about the rhetoric, it's about the legal consequence. Very briefly, the third case study, a big issue, which you heard of because the European Commission also tried to impose several sanctions on Poland, not effectively. The reform of the judiciary, the change in Supreme Court, creation of a new disciplinary chamber, also a special extraordinary jurisdiction, which allowed them to review the cases from 1997 till today. So the new judges, the law and justice judges, could have a different approach towards reading of the Constitution. And of course, also the reform of the National Judicial Council, called KRS, which now is packed by the judges who were chosen by the parliament led by Law and Justice Party. So they have their own people who decide about who are the judges, what kind of disciplinary measures will be imposed, and many other references. Last one, small compared to the others, but also Ministry of Justice was involved in a smear and hatred campaign to use the social media to try to denounce, try to create a negative image of the judges who were disloyal to the government, which is a proof of the times we are living at. But if it's institutionalized, it's bad. Very briefly, conclusions. Many people would say, you know, the problem of Poland is Zbigniew Ziobro, so it's a personal issue. It's his character. It's his approach towards the law, which is instrumental treatment of the law. Maybe, but he has an opportunity to do that because of institutional flaw, because he has the tools in hand. And the tools were created by that merger. So I believe this is the worst idea of how to construct the justice system. They do have a direct political impact on judicial and prosecutors' decision, which leads to the final thought that rule of law is definitely weakened in Poland, because they're imposing constitutionalization of politics the way they believe it's legal. So they're doing it in kind of, last sentence, way of using 2 types of tools. One, using newly created or recreated, redefined institutions packed with their representatives who think similarly. So they have institutions that are used to translate to the society what the law means. Also the issue of abortion and many other things have been involved. There's an impact on this in Poland. And secondly, even if, because they did it before 2016, they didn't have these tools, they would find lawyers among themselves, they would find certain institutions who would try to redefine or write legal opinions which would legalize, justify, because they believe they have the power to do that, because they're living in times of emergency, they're living in times of exceptionalism. I would end here. Thank you. Sorry to be so long. Thank you.
Excellent, excellent. Thank you so much for your points. So we have a lot to unpack from our three panelists, and we have about less than an hour left to go for the discussion. So I will just maybe start briefly with a question for each of the panelists. I was thinking about maybe trying to find some common threads, but actually so much was given and provided to us by the panelists that I want to follow up briefly. So let me just put this slide back up for visual purposes. And I want to start maybe coming back to Romania and talking about the fight against corruption. You had mentioned that it's considered a success story in Romania. Andrzej showed us Corruption Perception Index, and I'm just curious, what is the perception of corruption in Romania now, and then if you can just give us a few more details about this constitutional court, like why are they so involved in trying to stop the fight against corruption? Is it politicalization of the justice, or is it actually their own self-preservation, and it's actually more about the judges themselves? Yes, please. Yeah.
Thank you for your questions. Where shall I start? Why do, let me start in reverse manner. Why did the Constitutional Court interfere so much in the fight against corruption? That's a very classical thing. Whenever a state power doesn't have limits, or does not perceive its limits, it will go beyond. It's easy. Power corrupts everything, and it's the Constitutional Court was created as an instrument in the transition period, as proof that Romania is going from a communist regime, authoritarian and so on, to a democratic political regime. Like almost all countries in Eastern Europe, we have also created a Constitutional Court. The old judges were not so much trusted. This feature was taken from the previous transition from Spain and Greece and Portugal, where also the judges of the military regimes were not trusted. So in order to create a difference with the past, those countries, Spain, Portugal as well, Greece not, but Spain and Portugal have created the Constitutional Court, and they have meant it as an sort of a buffer between the very technocratic, legalistic details and the political arena, but it was not supposed to go into the politics. It was just supposed to support or maintain some policies. And the East European countries, and later on even some South Asian countries, were strongly encouraged to do so by the Venice Commission. Now we tend to forget also the role of international consultancy, which was there on the ground. And everybody said, well, this is a nice way to do it. If you really want to become a democratic country, why don't you take some model? You don't have to follow one, but you may pick and choose. You may just make your own a la menu, a la carte menu, but build yourself an institutional setting which would be conducive to democracy. And the Constitutional Court was meant as an instrument to support the democratization of the country. In the process, the initial, or the beginning, the first 10 years of existence of the Constitutional Court, it was created only in 1992. In the first 10 years, the Constitutional Court was actually, had as a general policy, a policy of judicial self-restraint. It would only intervene where really it was, a law was unconstitutional, but it would really preserve the margin of appreciation of the legislator, be it the legislator, the parliament, or the executive. So it was a nice arrangement where the court would really sanction the marginal errors, the true errors, but it would let the political institutions, the representative institutions, to do their job. In the second decade, however, the Constitutional Court started to perceive the potential for grabbing power. And it started to perceive that potential in a very interesting way, not directly in the relationship, in the interaction with the legislative, rather with the judicial. Now, this has a lot to do with history. Sorry, I will not go into too many details. We had judicial review in Romania. We had it à l'américaine. We had it since 1912. So Romania was not unfamiliar with the idea that a citizen, mind you, even before Kelsen, there was judicial review in Europe. It actually started with the Emperor, Franz Joseph, who simply accepted the possibility of any citizen in his kingdom to complain to the emperor for the wrongdoings of the administration. Okay, it was the precursor of the administrative. But this is where it started, and Romania had it since 1912, the possibility of any citizen to go in front of any court and just say, as a means of defense, I will do everything the law requires me to do, but I believe this law is unconstitutional. Can your court just set it aside and continue with the case as usual? That's American. That's the American way. And the regular courts had this power. They didn't abuse it. They didn't even use it. For years in a row, they didn't use it. But when, after the Second World War, and after the difficult involvement of Romania in the Second World War, the courts have rediscovered this power, they kind of were reluctant to do it, and it gradually faded out somehow. So when in the process of democratization, Romania was strongly advised, do take the European model, go along with the Constitutional Court. The regular courts said, what about us? We used to have this power, now you're taking it from us. And they were not told in so many words, but anyway, they somehow felt it. You're not trusted. We have to create a new institution because you, as communist judges, we will not just replace you, but you're not trusted. So when, after the first 10 years of existence of the court started to notice that there is some potential there for it to be more active on the political arena, the first opposition, the first limitation came from the regular judges. It was the judges who said, we don't want to deal with those 9. The Romanian Constitutional Court has only 9 judges. We don't want to deal with those 9. We are judges. They are appointed by politicians. So we would rather stick with our own jurisdiction. And the Constitutional Court was supported by the politicians in telling the regular judges, you should mind your own business. We are the constitutional ones and dealing with the policies. But when this attitude turned against the very politicians who were supporting the court in relation to the courts, to the regular courts, the politicians didn't like it. And in a very interesting way, the Constitutional Court discovered that it has a power, and then it started to instrumentalize it. I didn't put it in so many words, and I would not like to be quoted for that, but in fact, it is almost a way, as if the Constitutional Court would be, I don't dare to say the word corrupt, but it is instrumentalizing the power it has, and it's, in a way, not keeping the balance with regard to the Constitution, or not in all cases. There are cases where it does so. One has to be careful. But there are instances where one might wonder whether the appropriate balance wouldn't have been elsewhere than where the court found it. So, yeah, difficult to say that. And just a minor thing, if you allow, sure, yeah, to answer a bit to your question, but also to react to something that I've just heard. Talking about lustration, well, almost all our countries had to do with lustration. It reminded me of a very interesting experience that I once had. We were in a conference like this on comparative law in a very nice city in the south of France, where every year they have gatherings, academic gatherings dealing with a judicial review. And it was obvious I don't know how we got to lustration, but there were judges, constitutional judges from, you name it, every West European countries, including the United States, and us, from the Eastern Europe, we had a topic with the lustration. The German one was a bit uncomfortable, but not so much. For them, it was all in the past. The West Europeans were looking at us like, okay, that's not a topic, that's not an issue. But for us, it was really something that was terribly important at that time. And our shared experiences showed us that actually in none of our countries lustration has succeeded. Just to give you my country, the Constitutional Court has sanctioned the initiatives, the legislative initiatives, twice. First time it said that the law was not appropriately adopted, not in accordance with some parliamentary procedures, a tiny procedural detail to just cut off the law, and it declared it invalidated it in full. But when a second time the parliament said, okay, I may have wrongly done something with the procedures, now I'm doing it properly, can you please take a look also at the content of the law? The second time, the Constitutional Court said something like, if a Constitutional Court tells a parliament that a law is fully unconstitutional, the parliament should simply accept it and never ever start that legal procedure again. So the court simply refused to look into the content of the law and just said, my previous decision is fully mandatory, you just have to respect it. The law stopped, the law never existed. It never came into being. And that's something that it may be worth to pause and reflect upon. Thank you.
Thank you very much. Andrzej, maybe we could continue this discussion a little bit. I don't want to get too far away from your presentation, but I know you're an expert on Hungary. And maybe you could talk a little bit about the evolution of the Fidesz's role towards and positions towards their judicial system, and how politicized would you say the judicial system is in Hungary? Because it's often, at least from the perspective in Poland and external observations, would say that Hungary is often the roadmap for a lot of the Polish policies that came in after 2015, after the Law and Justice came to power. So, is that true? And how would you characterize the politicization of justice in Hungary? If you don't mind me going in that direction.
Yeah, sure. Well, it's a difficult question. I'm not a lawyer, so again, a caveat, yeah. But I will link it first to the corruption. It's often said by Viktor Orban himself when he is accused that, well, you have these cases that I also showed you. How come it's not accountable, etc.? He often says, well, if you know about the case of corruption, go to the police. And that's it. So it kind of, through the state capture, through the growing control of the institutions, it became very difficult to sort of fight with the corruption, which is not incidental, but became a part of the system. So in this sense, well, if you look at the Constitutional Court, is of course controlled by the Fidesz nominee. You have a prosecutor, which is, well, here in this case, these functions are divided. So as in the most European countries, there is a separate Minister of Justice and a separate prosecutor general. Doesn't matter. Still, it's a person which is connected to the party for many years. So so on practical levels, you have very limited sort of ways of countering these schemes, right? And they are so much sort of part of the system that that's almost impossible. I mean, you very rarely hear such cases. You had a case very recently, I mean, late last year, of a deputy Minister of Justice who was taking bribes. and it was revealed, and he was punished. Right? He had a court case. He was dismissed. But all the other cases in which you have kind of, I mean, everyone sees it. It's something that everyone knows. It's widely discussed. You have a number of reports about it in very details, how it works, how particular procurements, particular tenders are won by the direct allies of those in power, but actually nothing can be done about it. And here about the role of the external actors in that, of course, everywhere in all of the countries, at least all of the countries of our region, Russia and China, has this kind of subversive activity, which is sometimes revealed, sometimes not. You have court cases, you have in Poland, in many other countries. But in the Hungarian case, the problem is that it goes sort of, it's accepted by the government, right? So there is, it goes sort of hand in hand. So in this sense, it's very difficult to kind of counter it if there is no political will also in that. So answering briefly your question.
Thank you, Andrzej. And then to Poland, Pavel, you outlined quite well the changes that took place in Poland, especially related to the prosecutor's office. But I wanted to ask about the Constitutional Tribunal as well. And if, let's say, in theory or hypothetically speaking, if there was a change in government in Poland, I think next year will be parliamentary elections, so it could happen. How difficult would it be for an opposition government, which would come into power, to manage with this constitutional tribunal? You'd mentioned that they don't even recognize its legality, so there's this kind of question of whether it's even whether it's legal, the constitutional tribunal at the moment. What do you think that would look like? Is it possible to undo all these changes? And one last add-on to that question is: does the opposition already talk about separating again the prosecutor general and the minister of justice? Thanks.
Thank you very much. Very interesting question, and of course, trying to predict even the general direction of the election results next year, it's really difficult. No one really knows into which direction it goes, but we know at least partly what are the plans or ideas of those who are believing that they have already a kitchen cabinet waiting just to take over. So from the last element of your question, yes, they would prefer the division. They believe the merger doesn't help the system. I mean, potentially there's more difficulty in it. I mean, I agree with what you said, which could be a counter thesis to what I said, that it not only depends how it's constructed, how it's structurized, it depends on really who appoints. So the process of appointment is also important. And the question is whether these, even if it's divided, whether these judicial institutions are sovereign enough to have a choice of someone who, at least theoretically, would be independent, and other tools of control, of course. But coming back to Poland, so yeah, on one hand, you can hear that in the media that are supportive to the opposition party or against the government, they always are talking about Julia Przyłębska Tribunal. They're not saying it's constitutional tribunal. But I believe that if they want to preserve rule of law in Poland, if they want to even change the law, which will, I mean, take time, because talking about personalities, at least we can say they have tenures, which is good, because when you look into the US and the federal judges or the Supreme Court justices, president leaves someone for many, many years to come, as they have lifetime tenure. So at least here there are tenures. So similarly to the Law and Justice Party, they can try to impose legislation having a concrete majority in the parliament, but which will come into force in the future. Because on one hand, you can change some institutional aspects and elements of the operation of the court, but when you have judges inside who deny the possibility to go into the procedures that you're applying, this is really problematic. I think this is also a good moment to refer to a kind of a broader perspective of the role of the EU, where not all of these activities of Ziobro were reflected by the reaction of the EU institutions and the Venice Commission, as mentioned before, and also many other NGOs devoted to the independence of the judiciary. But there was a big issue concerning first the Constitutional Tribunal, but later the changes in the Supreme Court and the changes in the National Judicial Council. And the kind of, on one hand, external pressures, but also internal pressures. And I think also a little bit of political strategy of current president caused that he decided to be the voice to ease a little bit the tensions. That's why some of these reforms were limited, but still it doesn't change the fact that the main idea of controlling and having impact on how disciplinary chamber works, they're still in force. So, I mean, you can change the law at any time, of course, if you have the majority in the parliament. But the question is about the execution. The question is about the potential. If the opposition party wins in 2023, having 4-year tenure, there will be a chance that at least some of these judges would end their tenure. But I wouldn't want Poland to be a country, even if it becomes, democratic in the meaning that we have 4 years of one party governance, then the other, so it's like a healthy balance, that we would have every 4 years a complete change in the law because the tribunal would even diminish its role. And its role was really important, even if the very interesting reference to comparative illustration in Romania, thank you for this. Even if we consider, even if we like or not the decision of the Constitutional Tribunal, at least we know there's an institution having concrete powers written in the Constitution and in lower laws, which is used. Sometimes it's better, sometimes it's worse, but at least it's working. We have the institution. Now, the problem is that it's not treated by part of the society and part of the political establishment as the institution that can have impact. And of course, there's one more element to the story, if I may. Please remember that the Supreme Court in Poland, of course, it's not this judicial review court, but it's a court that can have impact on the result of the elections, because all of the suits against the, some different problems in the electoral process may come in the end to the Supreme Court. And that is also an issue. We've been hearing in the last days Jarosław Kaczyński saying that he is preparing, he used the word, we discussed it with Łukasz, he used the word army, that he's preparing an army to not to control officially, but to watch the elections, because he is afraid of, I don't know if he is looking into Trump's US experience of the stolen election, but he is using that argumentation. So maybe for them, the Supreme Court, maybe they believe, as Trump did, but he didn't succeed, that the Supreme Court will play somehow a role in helping them to preserve the governance. So this is another problem, but really difficult to predict. And today, as I never predicted that Trump would win in 2016, it would be difficult for me to say that the opposition has real chances to win. For today, I would say it's 50-50. There are too many diverse factors. Yeah. Thank you.
Thank you so much. Okay, let's allow the discussion to continue here. Yeah, Leon. Yeah. And if we know you, Leon, but please introduce yourselves and keep your questions short.
Well, thank you. Thank you for the question, which actually comes to the heart of what I was saying before. A constitutional court is not there to do the policies of the state, and it should not take the place of the legislative or of the executive in that sense. So the changes should go or should be done by the legislative or by the executive, or indeed by the case law, but that should be a generalized case law in the countries. However, there is one thing that I'm doing constantly. I didn't want to emphasize it too much, but actually what I've presented is the case law of the Constitutional Court as such, but all the criticism that I presented is actually, that's why I can do it. I have published it. It's in my separate opinions. Yes, the Romanian Constitutional Court has the possibility for the judges to write separate opinions. Their separate opinions are published together with the decision in the official gazette. So at least in terms of transparency, at least the public can read both opinions, or at least get a hint of what was going on during the deliberations, where contrary arguments, which that is the very sense of the deliberation, where judges present their arguments and they try to reach a solution. You know, everybody's trying to advance his or her solution, and then we confront arguments, and then at least that thing is done. This may contribute to the debate, but for the decision to be taken, I don't think that belongs. I honestly prefer a self-restrained court than a mostly pro-activistic one, which proved, at least in the case of Romania, not to be a positive experience. What would be the three other things, or maybe the two other things, because I just said one, to reverse? Depending, do we want to reverse? That's the other question. What is there to be reversed? Having a long-term perspective, well, Romania has pretty much advanced on the way of its integration to the EU. It is a solid and credible partner within the NATO. It has become a better democracy with all its flaws, but it's definitely better to live in the today Romania than it was in 10 years ago Romania, or maybe 10 years it was a bit better. No, sorry. Maybe in 20 years ago Romania, 10 years ago it was just immediately after the accession to EU, and it was really blooming. Now it's okay. So I think progress is not linear, but there is, you can see it. So I'm not sure that I would, or there would be a need to reverse, but what I certainly wouldn't like to see is something that may be just ongoing right now. So I will just mention it, and then I will refrain because I may have to talk about it in a different setting. What I would not like to see is indeed a reversal to a status quo ante, which goes back before the Romania's accession precisely. And there are some initiatives in Parliament right now that are questioning some of the progresses which have been done, and it seems to me that a question mark, a huge question mark, is upon them. But that's not. I can't say more about this. That's why. Okay, what I can do at my individual limited level, I think I'm already doing to a certain extent. I'm not writing separate opinions on each and every case where I could. But I don't. What can be done at institutional level? Well, I think a better, a more balanced positioning of the court would be good, and I'm trying to do this inside. And we are all actually we're all trying to do during the deliberations. We do take into account also how would this be perceived by the public, even if it's correct as a judicial decision. Will it be correctly perceived also from? One thing is justice to be done, another thing is justice how it's perceived to be done, and another thing is the perception on the justice from the political side or from the people's. So it's very delicate. And what can be done at the even broader, generally institutional level? Obviously, that's a larger decision. I think the last and ultimate solution are indeed the elections and how the people vote, and that's what we have seen this year in Hungary, where everybody hoped, and the result is here. And we shall see next year in Poland, and we shall see in 2 years' time in Romania. Thank you.
And I'm sorry, and we'll see in November in the US also, with reference to midterm elections. Yeah.
Thank you for a question to which I cannot answer fully. Yes, I've noticed the decline in some of the decline in popularity, and I will not dare to make any comments on the actual work as such, but the decline in popularity of some constitutional courts in Eastern Europe, and I'm following actually I'm proactively following what's happening in the neighborhood. Let me try to say something at least about the past. I cannot make predictions, I'm sorry. But the Romanian Constitutional Court had a period when it was really self-restrained at a time when both Hungarian and the Polish one, but mostly the Hungarian Constitutional Court, were highly proactivistic because they were missing a full constitution. It's famous that they only have the article with the capital and the rest of the constitution changed entirely and so on. And it was actually the Constitutional Court, porte-drapeau, they were the ones promoting democratization. They were actually heavily congratulated for being one of the, not just an important actor, but a vector of democratization in their respective countries. And it was this proactive attitude, totally opposed to the self-restrained attitude of the Romanian Constitutional Court back at that time. It was this proactivism of those constitutional courts that actually made their popularity. There's a huge difference between popularity and populism. Fine. And I will not discuss here what happened to those courts that now they have a different public image. But I think that both those courts, even when they were so highly proactivistic, they were not as powerful as people tended to believe them, general people. I think in the political spheres, it was known that they didn't have real power. They were just enjoying the acceptance somehow or the tolerance of the political actors. That's my personal view on it. Whereas the Romanian one just discovered activism lately, only during the past 7 to 10 years. It has been self-restrained for a very long time. And all of a sudden, because it was so heavily encouraged, because everybody told, you see, democratization happened so quickly in other places because they had a strong constitutional court. You're not as strong as you should or as you could be. And somehow the judges fell into this, I think it was a trap. And they all of a sudden started to become highly proactivistic, except that they probably missed the target or missed the point, or somehow in the process, they just got out of the normal way. And now we have a constitutional court which is, in the public, it is at times accused of being populistic. I will spare you most of the epithets that I'm reading, and I'm constantly reading the newspapers. Obviously, we have a press review at the court, and but one of the nice ones is the sour cherries. You know, they have this color. Our robes are color of the sour cherry. We are called the sour cherry morses. You know, some of my colleagues tend to have a certain corpulent, a certain consistency, and we are called the sour cherry morses. That's, yeah, okay. So, yeah, the public image is clearly a problem, up to the point where we actually, I'm saying I'm a part of that court. I mean, I'm criticizing, I'm making separate opinion, but institutionally I belong to it, and it hurts me as much as everybody else that such an important institution of a state, and such an important institution of a state governed by the rule of law, has such a bad public image, and that it has somehow deviated. In my opinion, it has sometimes it slightly deviates from its role. Is it populist? Well, before I joined the court, I have published an article on can constitutional courts become populist. Now I'm in the court, I can no longer say it. Thank you.
We'll have to look up that article, I guess. Other questions, comments for our panelists? Yes, please.
Thank you. There are two such cases which are very famous for Romanian public. Sorry, actually, it's a bit like in Poland. Judges are. We also had a special section for investigating judges. We just gave up to it a few months ago. Poland has resisted up to today, but still under threat. The investigations. That special section has performed investigations against targeted judges, and it's Camelia Bogdan one of them. Cristi Danileț is the other one. Camelia Bogdan has now made a professional reconversion and is now working in the United States on still also on the fight against corruption. Cristi Danileț is in Romania, and he's living of whatever his colleagues managed to put together as money as to provide him, because he doesn't have other sources of no other revenues. And the pattern is the same. When Camelia Bogdan has won actually 2 cases at the European Court of Human Rights, and now they have delayed the publication of her of the last decision. Cristi Danileț didn't even have a chance to go to the European Court of Human Rights because he was not handed the decision. So yeah, the same thing. So it's a pattern. And yes, the Romanian law says that the arguments of a case have to be published and provided and given to the parties within 3 months, particularly if it is about a criminal law case. But in civil law cases, they can be provided within 6 months. And since these were not criminal cases, but they were civil law, it was administrative, it was responsibility, so it was 6 months. And 6 months happens to be also the deadline for a final case to be addressed to the European Court of Human Rights. So this slight coincidence made it that, yes, if the decision is handed to the person at the very last day, unless the person is wise enough to foresee the arguments that might be in the decision in order to prepare and be able to do it in the very same day, you'll never reach the European Court of Human Rights. And it is because of the experience that they had with Camelia Bogdan in 2 cases before that they started this new pattern. Now, to be really nasty up to the end, that's another decision where I have a separate opinion, so I can talk about it. The Constitutional Court had last year a case where it was asked whether this provision in the law, which says that decisions of courts in criminal cases, that they have to be handed to the respective parties within 3 months, together with the argumentations, if this would be constitutional. And the court declared it unconstitutional. So henceforth, from last year onwards, in criminal cases, all decisions, the day when they are pronounced by the judge in court, they are also handed together with the arguments. This is the normal thing, actually. It was abnormal what was happening before. It was a terrible outcry all over in the public that judges will now have to work more. Yes, but one of the arguments that was brought against this is that the decisions of the Constitutional Court don't have to be published at the moment when they are pronounced in the public hearing. The decisions of the Constitutional Court, they may take up to 6 months to be published, and there is no rule on that. So the Constitutional Court was imposing on the criminal judges something that it doesn't respect. And yeah, okay, I had a separate opinion on this apart, but this is why I can talk about it. But there were also others saying that if this should be the case, that the decisions must be provided to the parties the very same day when they are pronounced, then why make it a separate, why make it an exception only in criminal cases, and why not do it in all types of cases? Because after all, justice has to be rendered in the same way. We talk about justice here. Well, the court provided some arguments why in criminal cases is more important than in other types of cases, and why for the Constitutional Court this doesn't apply, but it does apply to the regular criminal judges. That's my comment. Thank you.
Thank you. Yes, please.
Thank you very much for your question. I mean, this is a question that may refer to the broader approach of Peace, Law and Justice Party towards, we can say generally, European Union or European Union institutions, and especially the court, that it's not the only decision in recent years which is somehow clashing with what peace beliefs should be done. And there was a very fruitful discussion in the first the first panel about sovereignty. And this is very often the argument that they are using. Yes, they love EU with regard to the financial and economic support, but when it goes to the values and when it goes to the analysis of the law and pointing out that some of the reforms, for example, or some of the direction of the policies they are going is not appropriate, it's illegal, it should be changed. Then suddenly, of course, they tend not to listen, or they're trying to criticize. And we've heard numerous times also from Ziobro kind of reference not generally to the role of the ECJ, but of the judges. Of course, there were references often also heard comparatively in the US. How come it's possible that a tribunal which is external to our legal system will tell us what we can or what we should do, but of course from the perspective of the legality, of the perspective of the primacy of EU law and the role of ECJ, for me as a constitutional law scholar, it's obvious that it's binding and it's obvious that it should be implemented. And I didn't refer to the word populism, which was also used several times in different presentations, but I think this is also how they're trying to glue, how they're trying to put all the puzzles together with reference to the attack on sovereignty, the attack on Polish nation, attack on patriotism, attack on a system that they're also the elements trying to defend the system that peace is trying to fight with. And as you were asking about the election, I think one of the elements and how they will cope with any other thing that will be defined or done or announced by the EU institution in future, which would be against peace as they would defend, they would use the same argumentation as Kaczyński and Ziobro are using. When they were trying to impose the judicial reform, even before the election, when they were doing the campaign, they were always referring to caseload. They were referring to individual cases where they're trying to prove that the judges make mistakes, so the system is not working properly, we should restructurize, and so on and so forth. And then when they came to power and they started that process of reforming, everyone realized what is the main purpose. It's not only institutionalizing, having impact on these institutions, but it's also decommunization. But decommunization is also used in Poland still. I wonder how long we can be referred to in many researches as a post-communist country. On one hand, you can say we will always be a post-communist country, but on the other hand, from the perspective of how you use it as an element of politics, I mean, at least you would consider after 30, 35 years, it should be over. But they're still using that argumentation, and it's very populist. And I think they will also refer to the ECJ rulings, this one and the next ones that could come, that it is against the whole process of having impact of Polish government on what they should have. And so the values will be used there, in my opinion. Thank you.
Yeah, that's a good question. I'm not sure actually is there any sort of wider framework. I can tell in this case, the EU played some constructive role. I mean, in the sense that in both of these cases I was showing, these two sort of big projects, the EU played a role. It tried to enforce some transparency and some, let's say, some competition also. So from different sides, for instance, before giving a green light to these projects, the Commission asked asked Hungary, in this case, to, for instance, if it did not have a tender for the whole project, to at least have open tenders for some parts of it. So at least to have some sort of fair competition, or yeah, that's basically how the EU tried to sort of improve this situation, but it didn't have too many tools at hand. So it could check the issue of equal competition, but otherwise, well, it was a sovereign political decision of the country. And if there are irregularities, it should be sort of checked by the local authorities. And in this sense, the EU played a somewhat positive role, but rather limited. Thank you.
Okay, we have just a few minutes left, so maybe I'll allow the panelists to give some wrapping remarks, some concluding remarks. Maybe look at what the outlook of rule of law and corruption is for the near future. We kind of started talking about that a little bit, but I would just like to hear some last remarks from each of our panelists, and maybe Pavel, we'll start with you. We'll come back this way.
Thank you. I'm aware that when we came here on Sunday, there was a conference on pessimism. I mean, we didn't attend. We're sorry, but we probably know the approach of most of the panelists. And I mean, you were very happy when we met you on Sunday. Still, there were a lot of references today also to the unsure future. Przemysław was talking about chaos. I think we can observe it already. Sorry for another reference to the US, but I feel a little bit more comfortable with reference to a country which I researched for a longer time. And similarly, we can say, I mean, of course, different comparisons than here, closer, Poland, Hungary, and Romania rather than the US. However, with the reference to the situation in generally and the uncertainty of the outcome of elections, in how the people, but also the politicians, will react to what is happening. For example, I'm not really sure, after listening to what Kaczynski is saying now, if the opposition wins, what would be the consequence? I'm not talking exactly about the, June 6th American consequence of what Trump did and his supporters, but I think that these are, because of what all of the issues that we are talking about here from the Polish perspective, the elections of 2023 are the most decisive ones. I wouldn't say for ages to come, but definitely for a decade to come. We can observe it, for example, in the higher education system. We didn't talk about this, but in Poland, there are efforts not only to limit the independence of judiciary, prosecutor offices, the media, but also to have impact on the education system. We used to be very much dependent on the government in the communist times and in the early stage of the post-communist era. Today, still, we can imagine and we believe we are autonomous, but already you observed in schools, and you observe it as an effort in institutions of higher education, where there's a big change, similar to what we were discussing, what they did with the law regarding the operation of the judiciary or constitutional tribunal, to create norms that are working, that are retrospective, not prospective. So lex retro non agit does not exist in many respects, just to have the aim of having control of the content They are using the arguments of freedom of academia, freedom of speech, but as a matter of time, I think they're trying to limit it. So I'm just giving an additional element for Poland. I do not know much about other countries and their elections, but for Poland, this election is very crucial. Many people believed, you know, the situation in Poland in 2005, you probably know it, there were two main parties, as they are today, Law and Justice and Civic Platform. And the majority of people who voted either on Law and Justice or Civic Platform most of them didn't really care, because they believed there would be a huge coalition of the solidarity movement, of those who are considered, you know, a little bit liberal, but also right-wing. So, I mean, they were closer. And suddenly something happened. And I think this was a decisive moment in modern history of Poland. And 2023 is another such a decisive moment. It would be 8 years of their governance. And there were also similar period of time of the governance of Tusk. So I think this is a very important moment, and the opposition parties should use all the argumentations that are being brought also by us, all the argumentation trying to reflect to the society. But honestly, my last thought is like this. We can speak here about big values, rule of law, democracy, important for us and important for a large part of the society. But for the majority of the society, it's economy full. So if the inflation and if many other situations in like social aspects in Poland are getting really worse as predicted, only this may mark a significant change, with all due respect to what we come here with. But we should be ready with the solutions for those who will come later. Thank you.
Thank you. Andrzej.
Okay, a very brief final remark. I think that the change should and will be only successful if it comes from within. So the external actors, whether authoritarian, will exploit this situation where there are sort of conducive circumstances, or the democratic actors will also kind of try to facilitate the change in a positive direction. But eventually, I don't, honestly, after looking at Hungary for the past 12 years, I don't see much actually positive kind of effect of the external sort of impact. So I think it's difficult, and I honestly don't have an answer when it will happen. Probably not very soon, but I think it should come from inside. Thanks.
Thank you. I think the morning panel referred to democratic decay, and there are plenty of studies on this one. I think this one is referring to the decline of the rule of law. And I was reading The Economist in June 2022. The Economist had an article in its international section titled "Overruled: Justice in Retreat." That's what it's obviously the reality. But this, somebody asked me at lunchtime, what is my attitude? And I replied, well, I'm resilient. Whatever it comes, I think we can do it. Of course, one has to take into account the circumstances and the context, but with slight adjustment to the context, I think if it's not the politicians that will take us there, if it's not the courts that will take us there, I'm confident that the average people and the common sense of the regular guy in the street will finally manage to do something. It's not to make a comparison with the current situation with the Second World War, but I keep telling to myself, how did the people in the early 39 or 40 or 41 or even 42 felt when they knew that the Nazi regime is really bad and they couldn't see the light, and yet they kept going on. The current situation is nowhere near what it used to be back there. So yeah, I'm not saying that we should not make a correct assessment of the situation, but I think we should keep looking for solutions. And on my side, I'm resilient. That's it. Thank you.
Thank you very much. I think a great way to end our discussion. Please join me in thanking our panelists. And thank you for your comments. And we hand it over now to Leon. Yes.